Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Good afternoon, Mr Atkinson. Can we turn to Peter Holmes, please?
Yes.
In paragraphs 309 to 333 of your report, no need to display them, but they're on page 114 and following, you deal with the prosecution of Peter Holmes. One of the things that happened was that in an interview, Mr Holmes said, "It's the Horizon system that has let us down." That was an interview taking place in September 2008. That was after a civil claim involving the Cleveland's branch and Mrs. Julie Wolstenholme had been settled after she raised Horizon integrity issues, after the formation in December 2005 of a group to examine Horizon integrity issues, after the trial of Lee Castleton involving Lee Castleton in 2007, in which he had directly challenged the Horizon system, and after a jury had acquitted Suzanne Palmer in less than 10 minutes in 2007, her having raised issues with the integrity of the Horizon system. Was there, to your understanding, any investigation of Horizon integrity or the figures produced by Horizon?
No.
The investigation report recorded that Mr Holmes had spent many years in the police service and that he had been a sub-postmaster at the Monk Seaton branch office for 6 or 7 years. He was of good character. Should such good character have been brought into account when considering the investigation of an offence or the merits of prosecution?
It should certainly have been a factor in the public interest test. It would not have been the only factor or necessarily the decisive factor, but it was a factor. I'm afraid I can't speak as to whether it was taken into account in the charging decision because the public interest didn't get a mention. It was a factor relevant to the assessment of Mr Holmes's credibility. He, as with any person of good character, their good character is a factor in their favour in the assessment of their credibility. Again, not decisively so, but a relevant factor in that regard as well.
In fact, it was used against him in the investigation report.
Yes.
Because he said that he hadn't reported the accruing shortfalls showing on Horizon for some 11 months. And the investigator said that it was incredulous that he should do so, not have done so, having spent many years in the police service and having been the sub-postmaster for 6 or 7 months, 6 or 7 years at Monk Seaton. So it was used against him. Ought his previous position and the longevity of his service to be a factor in deciding whether to take seriously concerns raised by him in interview about the reliability of the Horizon system?
Certainly not as a reason not to take those matters seriously.
And in reality, does it matter who you are if you raise issues such as this in an interview, whether you've got good character or not, as to the pursuit of a reasonable line of inquiry?
No, but as I said, the fact that you are of good character may support your credibility in raising an issue and perhaps give an extra underlining to why it needs to be investigated.
Thank you very much. I'm going to move over the cases of Seema Misra, Lynette Hutchins, Joan Bailey and Alison Hall and turn to Alison Henderson. That's paragraph 515 of your report to 519. So I'm so sorry. Yes, in paragraph 515 of your report, when you're dealing with Mrs. Henderson's case, you say that her case was one where acceptance of her plea was dependent upon repayment and a lack of criticism of Horizon.
Yes.
And that's a theme that you return to in 649, which we looked at earlier.
Yes.
When you're making your general points. Would you accept that there is a difference between acceptance of a plea on the one hand and acceptance of a basis of plea on the other?
Yes.
You cite in 506, that's page, excuse me, 179. If we just go to that 179. You say on the 16th of November, on the date on which it appears the second defence statement was served, Prosecution Counsel Diane Chan reported, quote, "have spoken to defence solicitor who indicated the defendant may be willing to plead to false accounting and pay money back, taken instructions from Chris," that's a reference to Christopher Knight, the investigator, we think, who has confirmed that he would be happy to proceed on that basis. And you say that Mr Bowyer's 2014 review recorded the defence had told the investigator by phone that the defendant might plead guilty to false accounting. And then Mr Wilson's response to Diane Chan's email said, clearly, if there were to be a plea to the false accounting, but on the basis that the Horizon system was at fault, that would not be an acceptable basis of plea for the prosecution. Do you agree that what was being said by Mr Wilson was not about acceptability of plea, but rather acceptability of a potential basis of plea?
That's certainly an interpretation of that. It's not, I have to say, the interpretation the Court of Appeal reached, but it is an interpretation of it.
Was the potential for a guilty plea to false accounting accompanied by repayment of shortfall an issue first raised by the defence?
That's not altogether clear because it's not clear who in the conversation between Diane Chan, who was prosecuting counsel, and defence counsel, who it was who first raised repayment. Certainly it was part of what was communicated by her to those who instructed her.
And so it's not clear who was tethering repayment to the plea?
No.
What's the basis for your view that the Post Office made acceptance of the plea to false accounting conditional upon repayment?
In part, I confess I was influenced by that being the finding of the Court of Appeal in that case, and I quote that at paragraph 511.
Yes.
And the fact that I was influenced, I suspect, also by the fact that by the time I dealt with the case of Mrs Henderson, I had already dealt with other cases where there had been that connection, those, for example, of Mrs Hall.
Thank you. Can we move to the case of Grant Allen, please? Which you address from your paragraph 516 onwards on page 182. And can we look at some of the underlying material here, please? Can we start, please, with poll 309 7138? Again, this principally involves a series of questions about liaison between Post Office Fujitsu and Mr Jenkins.
Yes.
In the preparation of evidence, whether witness statements or reports, for the prosecution of Mr Allen. If we scroll down, please. Keep going. And one more. Thank you. An email from Rachel Panter. If we just scroll up, we'll see that it's on the 16th of November. Thank you. Rachel Panter, she is a lawyer at Cartwright King, to Gareth Jenkins, As you may already be aware, your expert report detailing the reliability of the Horizon system has been served as evidence in a number of cases. We've seen a similar email to this, I think, twice yesterday.
Yes.
To date, most, if not all, cases raising Horizon system as an issue have been unable or unwilling to particularise what specific issues they may have with the system and how that shapes the nature of their defence. I'd like to serve your report in each case listed below, and we can see that one of them is Mr Allen's, number 6, at the Chester Crown Court.
Yes.
If we scroll down, please. Just under the Grant Allen highlighted in yellow part, it says, I'd like to serve your report in the remaining cases and have attached a case summary of each listed above, so you may familiarise yourself with the facts of each case. And then if we go over the page, sorry, it was at the foot of the previous page, actually. In order for me to serve your report in time, please could you either send copies of your reports via special delivery or as an email attachment. And the paragraph above, the request, was to read the case summaries, send 5 original signed and dated copies of your report to her.
Yes.
Can we see what happened next, please? FUJ 0015 3856. And then scroll down, please. And again, and again, and again, and again. Mr Jenkins replies by saying, can't you use the report I've already sent you? There's no mention of the case on the report, i.e. no mention of any of the cases that you have listed. You should really be addressing such requests through Post Office Limited rather than directly to myself. There's no commercial cover. And then up the page, please. Concerned about the approach taken. We saw that yesterday, and then up the page again. And to keep going to Ms Panter's email. She says, as I provided a list of cases, rather than approach each individual investigator to each case and then repose the same question, I thought it would save time and duplication. In response to your email, Gareth, I do intend to use the report that you've already provided. It doesn't matter, you've not mentioned a specific case in your report, as there has not been any specific criticisms raised by the defendants provided in my list of cases. And then reading on, what I propose to do is serve your statement on each defence solicitor so that the issue of Horizon is addressed. That will then place the onus on the defence to specify what, if anything, they say is wrong with the Horizon system. That's why it's important for you to consider the case summaries that I've provided so you're familiar with each case. Looking at that exchange, as it stands at that point in time, were there problems with the approach that was being taken?
Yes, we considered yesterday the issues potentially with the generic statement and what it did or did not do. And here we have further communication in relation to that generic statement and the decision that was taken to rely on effectively bald assertion that there was nothing to see here in relation to the operation of the Horizon system, rather than to look at the data on a case-by-case basis, on a branch-by-branch basis, to identify whether there was something to see or not, and if so, what.
So the Post Office wasn't itself considering each case on its merits, and not instructing Mr Jenkins as an expert in each case.
No, that's right. It was effectively a one-size-fit-all answer to any suggestion from any postmaster that there may be an issue with Horizon without actually looking to see whether there was in their case.
The post office was not providing Mr Jenkins with any instructions specific to the case in question.
Or data, no.
And it was proposing to give, or it did give, Mr Jenkins nothing more than a bare case summary in each case.
Quite.
That's aside from the limitations of the statement itself, the generic statement itself.
Yes.
What did you understand the provision of a case summary to be for? What was its purpose?
Again, it wasn't altogether clear to me what its intended purpose was, other than so that Mr Jenkins would know perhaps which post office it was, the name of the defendant, the amount of the shortfall. It perhaps would have given him some indication as to what the postmaster had said in interview about it, but it wasn't asking him to do anything with that information
Because
other than to know it.
I'm sorry, as we see here, the post office was, via its agent, telling Mr Jenkins it didn't matter that he had not referred to a specific case in his report, and yet it was telling him to read the case summary
Yes.
for each case.
Yes.
And was that approach made better or worse by the fact that the statement on its face did not explain that it was itself responsive to the 4 questions that we saw earlier?
It made it worse in the sense that no one coming to a particular case from a defence perspective, for example, or a court's perspective, would properly understand what this statement was or where it had come from.
And the genesis of it.
Absolutely.
And if it's right that it contained limitations, what those limitations were.
No.
Can we go forwards to FUJ 0015 3865? We've moved forward now to the end of November, and an email from a different solicitor at Cartwright King in the case of Allen and also in the case of Sefton and Neil, Andrew both, copied to Miss Panter, to Mr Jenkins. Please find enclosed outlines of the 2 cases which involve me. Of the 2, Sefton and Neil is the more urgent. Concentrate on that one first. The Allen case is only for plea and case management. On the 10th of December, in an ideal world, I'd like to serve a report before the 10th if possible. That doesn't improve the extent of the instructions that Mr Jenkins is being given, does it?
No.
And if we look, please, at FUJ 0012 4105. Mr Jenkins replies on the 3rd of December, adding, I think, Penny Thomas to the chain, saying to Mr Bolge, thanks for the info you've supplied me with me on these 2 cases. I thought I should try and clarify exactly what you want from me. My understanding from Rachel was all that is required is a signed version of a standard report I produced a couple of months ago. If that's the case, I can get that produced, scanned and emailed to you in a couple of days. However, having read through the info you've given me, perhaps you want me to cover some further things, some observations. And then Mr Jenkins sets out some further lines of inquiry.
Yes.
Number 1 in the Sefton and Neil case, and number 2 contrasting the Allen case to the Sefton and Neil case. Would you agree that at this point, Mr Jenkins appears to be seeking clarification as to exactly what it was that the lawyers wanted him to do, given that they wanted a standard statement, because these cases, they said, didn't give rise to specific horizon systems.
It's a combination of seeking clarification, because he does say that he's trying to clarify, but also an offer of further help that he could give on particular issues that he's spotted from the case summaries, I presume, that he had seen.
Yes. Can we move forward to FUJ 0015 3881? And if we scroll down, please. And again. And again. And again. And once more. Just stop there. If we just scroll up to catch the date, it should be the 4th of December, from Mr. Bolt to Mr. Jenkins. In the case of Allen, I've just spoken to the solicitor for Grant Allen, then skipping a paragraph. I attach an extract from Mr. Allen's interview. As in the case summary I sent you, he's trying to suggest that an initial loss of £3,000 is attributable to lost data, which has not reached head office because of installation problems. Are you able to comment on this scenario at all? Ultimately, we would need to discredit this as an explanation that holds any water. He denies stealing the subsequent losses, and therefore, by implication, may be seeking to blame the system for these losses as well. Is the email from Mr. Bolst, the lawyer, consistent or inconsistent with the proper instruction of an expert, in that it appears informally to ask Mr. Jenkins if he can comment at all on a defence explanation?
It's inconsistent, but not just for that reason. There's potentially no issue, depending on how it is done, with putting a scenario to an expert and asking for their assessment of it. But here, the tenor of the message is rather different. The use of the word "we," ultimately we would need to discredit this as an explanation that holds any water, and the approach being to discredit this as an explanation that holds any water. Neither of those things really fit, well, not really fit, neither of those things fit with the instruction of an independent expert by someone acting as a Minister of Justice.
So rather than doing what it should do, which was, if it hadn't been done before, to state the expert's duties of independence, it actively sought to suggest the outcome.
Yes, and that they were working as a team to get there.
Can we look, please, at FUJ 0015 3881? That's in fact this document in the reply further up the page, please. If we carry on to see Mr. Jenkins' reply, and if we keep going. So it's the next day, 5th of December. I've had a look at the statement here, and I think it might be helpful to have a dig as to exactly what went on in the branch at the time of the loss. I think I understand what he's claiming. However, where there are comms problems, it's normal to recover any missing data once the comms are sorted out, provided it's within 35 days, so this shouldn't be a reason for a loss. Also, there are processes in place to retrieve outstanding data where there are extended comms issues lasting more than 7 days, so as to meet contractual obligations. I could just make a general statement relating to that, or if we retrieve data from the time, I could check out exactly what is happening. Skip the next paragraph. We should note, we have not requested any, Post Office has not requested any audit data, nor been asked about help desk calls. Is it worth asking Post Office to request such data for me to examine before putting together a specific statement? Or is a simple generic one sufficient, and then some cost issues. So Mr Jenkins highlighting no request for audit data or help desk call records, and that there are two ways of going about this, and asking for instruction as to which the prosecutor required.
Yes.
If we go further up the page, please. Second line, Mr Bolt's reply. I would appreciate if you could add your general comments at this stage regarding the safeguards in place for comms problem to your statement. Send this to me as before. I'll refer back to the post office to consider whether we go on to request the retrieval of data for your further analysis. So this exchange, I think you'll agree, shows that Mr Jenkins informed the post office lawyers that he could examine the data to work out, quote, exactly what had happened at the branch.
Yes.
The post office said that they didn't want this to occur in response in the first instance. And if we look, please, at poll 308 9380, we should be able to see an email between Mr Bolt and the investigator. Please see Mr Jenkins' report. I'd asked him to look at non-polling issue raised in the interview, and I believe that he dealt with it adequately. Gareth tells me that it's in fact possible for him to retrieve the actual data from this time to see what actually occurred at this branch, and that the retrieval of the data is free to poll. It would take approximately 2.5 days for him to look at it and analyse what it means, and this will be chargeable to poll at £2,500. I've told him that at present we do not wish to pursue this option unless it becomes unavoidable. And then some instructions. Mr Jenkins then signed a witness statement in Mr Allen's case on the 17th of December. This was identical to the general statement, the generic statement that had been signed back earlier in the year, except for the additional paragraph that had been included addressing the non-polling data. Can we look, please, at that, at poll 308 9007? Poll 308 9007. Thank you. This is the statement dated 17th of December. It's quite hard to read. I'm not going to go through it because we're familiar with it as the generic statement. Just look at the addition, which is on page 2. And if we scroll down, so if we just scroll up a moment. He says, I've been asked to provide a statement in the case of Grant Allen. I understand the integrity of the system has been questioned. And this report provides some general information regarding the integrity of Horizon. And then if we scroll down. There is then, in the paragraph underneath, the explanation, or Mr Jenkins' evidence on the non-polling issue, and then over the page. At the end of that paragraph that's at the top of the page, Mr Jenkins says, I've not had an opportunity to examine the detailed logs for this period to see whether there were any issues. and any justification in the claim that this resulted in apparent system losses of £3,000 as claimed.
Yes.
So he's provided the generic explanation beforehand,
Yes.
but made it clear, is this right, that he's not actually looked at the data.
Yes.
You tell us in your report that this was an unfortunate failure in the evidence, given that he, Mr Jenkins, was aware of the specific issue raised by Mr Allen and didn't follow through in the investigation of it. But this appears, however, to have been a post office decision.
Yes.
Looking at that underlying material, that can come down, thank you, that we've examined, rather than it appears to have been a post office decision not to obtain this data, the evidence suggests that it was a post office decision not to obtain the data.
Yes. The material that you've just gone through is more than I had seen when I wrote my report.
And so would you agree that it's clear that in the face of Mr Jenkins saying that the obtaining of that data would resolve the question of what had happened in branch, the post office took the decision not to obtain the data?
Yes.
Was that consistent or inconsistent with its duty to pursue reasonable lines of inquiry?
Inconsistent.
And consistent or inconsistent with its duties of disclosure more generally?
Inconsistent.
In paragraph 545 of your report, which is on page 192, you say, so 192, uh, 545, thank you. The greatest concern in this case is the instruction of and reliance on expert evidence from Mr Jenkins to rebut any question as to the integrity and reliability of Horizon. First, this is because his offer to examine data relating to Mr Allen's branch and his complaints was rejected in favour of a generic statement. We've seen that in the underlying material.
Yes.
This was clearly a missed opportunity for which little justification was advanced. Do you stand by that comment in the light of the underlying material?
Yes.
Secondly, given that his generic statement was relied on, it is of a note that Mr Jenkins was in possession of material directly relevant to that question, which is nowhere referred to. His duty of disclosure ought to have at least required consideration of this, and I've seen no communication to suggest this. Again, do you stand by that comment in the light of the material we've looked at?
Yes. And I also have in mind there the material I'd seen in the context of the case of Mrs Misra and the discussions back in memory from 2010 about bugs in the system, and it is for others, not me, to opine as to whether those bugs had any potential relevance to the issues in Mr Allen's case. That the generic statement didn't leave any room for there being any apparent bugs at all in the system, and that, I think, was the concern I was also addressing there.
You continue, a generic report was served, which was flawed both in relation to the issue and also in relation to the limitations of the analysis of actual data that would have confirmed whether the Horizon system was operating correctly or not. Whilst there was discussion of this with Mr Jenkins, there does not appear to have been any disclosure of these important limitations. These represented very real disclosure failings in relation to expert evidence that the prosecution was relying on. Dealing with the two things that you addressed there, content of the report first, then disclosure second, you say the report, the statement was flawed in relation to the limitations of the analysis of the actual data that would have confirmed whether or not Horizon was operating correctly. Given that Mr Jenkins had indicated to Mr Bolsh that the data would show what had happened at the branch, given that Mr Bolsh, in conjunction with the investigator, Mr Bradshaw, had decided that Mr Jenkins shouldn't review the data, and given that Mr Jenkins stated in his witness statement in that paragraph I showed you that he hadn't examined the data, Would you agree that it was the Post Office that was responsible for that flawed approach?
Ultimately, yes.
As to disclosure, which is the second and third sentences of that passage I've just read you there, who was responsible for the very real disclosure failings that you identify?
Well, the answer is both the Post Office as the prosecutor and Mr Jenkins as the expert, because both had disclosure responsibilities. And it was for the expert to comply with his responsibilities as an expert as to disclosure, and it was certainly for the Post Office as the prosecutor to comply with theirs.
Thank you. Back in paragraph 528 of your report, which is on page 186, you refer to Mr Jenkins' September 2010 witness statement, or report rather, concerning the receipts and payments mismatch bug.
Yes.
And state that he did not disclose those issues in Mr Allen's case.
No.
And I think that's one of the things you were cross-referring back to
Yes.
there.
Yes.
The cross-reference back to the Misra case. And then forward to paragraph 540, you say that that omission is of particular concern.
Yes, insofar as I understood Mr Jenkins' report from September 2010 and put that against questions of the integrity and reliability of the system that his generic statement sought to address, it seemed to me that there was a disjunct between what was known by him and what was set out by him.
And as we've seen in paragraph 545, you said that Mr Jenkins' own duty of disclosure ought to have at least required consideration of disclosure of that issue, and you have seen no communication to suggest that occurred.
That's right. Because, again, and I may just have completely misunderstood the technical nature of all of this, but on the face of it, the September 2010 report represented material that was inconsistent with, or potentially inconsistent with, conclusions that he was asserting in the generic statement, and as such he had a duty to draw attention to that, irrespective of the prosecution's own unquestionable obligation to do so.
Do you agree, however, that in the material that you have seen, there's nothing to suggest that the Post Office informed Mr Jenkins of any disclosure duties that he owed personally, and in particular at the time of the provision of the generic statement as an expert?
No, that's right.
I think it's right that your knowledge of the Misra case would indicate to you that the Post Office lawyer in that case, John L. Singh, was aware of the Calendar Square bug, the locking issue that had caused transactions to be lost. Mr Jenkins emailed to him saying that there had been 200,000 faults recorded on the system, and the provision of the receipts and payments mismatch bug report to John L. Singh.
Yes.
Is there anything in the papers to suggest that in the Allen case, Mr Singh considered that these needed to be explained or disclosed when the generic statement was being sought?
I'm afraid not.
And more generally, is there anything to suggest that Mr Singh gave consideration to whether any of those issues needed to be referred to or explained when the generic statement was being sought, i.e. not just in the context of the Grant Allen case?
Not that I've seen.
ought the drafts of Mr Jenkins' original witness statements, in this case Grant Allen, to have been recorded on the schedule of unused material?
As in drafts of the generic statements,
Yes.
as it evolved in this case, yes, they should.
And in particular, would you agree that that may have revealed the extent to which Mr Jenkins had been asked to address 4 questions and whether he had understood that he was being asked to answer only those questions and nothing else?
Yes.
Have you seen any evidence that in Mr Allen's case, the Post Office gave any formalised or reasoned consideration to obtaining, recording and then disclosing information about Horizon hardware or software faults held by other departments within the Post Office?
No.
A duty of disclosure doesn't start with the prosecutor going to third parties. Is that right? It must look at which material it itself possesses.
Yes, I mean, it can think about both things at the same time, but it has to think about what it's got itself, absolutely.
What would you have expected for a prosecutor of this nature, a repeat player of many years vintage? It had been in the business of prosecuting people for hundreds of years, to have had by way of systems for retaining, then obtaining by a prosecution division, analysing, recording, and then disclosing.
Gosh. As a prosecutor, they should have recognised that they had duties under statute to complete the 3 R's in relation to material. They needed to recognise that they were relying on the operation of a computer system as the basis for a whole series of prosecutions, and that the reliability of that system was a potential issue in those cases, and that material that was relevant to the question, or potentially relevant to the question of reliability, had to be retained, had to be reviewed, and had ultimately to be disclosed. And they had to recognise that if they were in the criminal law department, and that the material as to the operation of the Horizon system was kept in a department down the corridor, they needed to go down the corridor. They couldn't just look at what was in their own office.
Did you see any appreciation by either the investigators or the lawyers that there were lots of other departments down the corridor, including departments that had as a function liaising with the manufacturer and operator of the system, Fujitsu, over faults with it?
No, I think the only departments that would get mentioned in, for example, investigators' reports, other than the criminal law department that they would be sending their report to, are the contract managers and the auditors. And that's because it was the auditors that were identifying the shortfall on the system in the first place, and the contract manager who would be making a decision about whether to sack the postmaster or not. I think that was it.
And so no recognition that down the corridor, as you put it, so elsewhere within the business, there were whole teams of people, most of whom were called managers, whose job it was to liaise on a daily basis with the post office, or between the post office and Fujitsu, over Horizon faults.
Whether they appreciated that or not, the material I've seen doesn't say, because it doesn't mention them.
No. Instead, was the the vista that was looked at by investigators and prosecutors, what is within the investigation team and what is within the prosecution team, sometimes extending to what happened at audit.
Yes, and so by way of example of that, they might, because they had it from the audit, look at transaction logs, which are derived from, as I understand it, from the Horizon system, but were things they had because the auditor had got them. They wouldn't look at anything that they hadn't got as a result of that process, or ask for it.
Thank you. Can we turn to the case of Angela Sefton and Anne Neil?
Yes.
And I think you've noted that these cases were being dealt with in an overlapping way, and including in an overlapping way with Alan. Is that right?
Yes, and indeed the email from Miss Panter we looked at earlier had a little list of cases, including that of Mr Allen, including that of these two, and Mr Ishak as well.
And therefore, similarly, if we turn up FUJ 0012 4105, in the case of Sefton and Neil 2 on the 3rd of December 2012, Mr Jenkins is making the point back to Mr Bolt. Please tell me exactly what you want from me, also in relation to the Sefton and Neil case.
Yes.
And he makes the point in the email that he hasn't been presented with any audit data relating to any of these cases, including Sefton and Neil, to examine.
Yes.
And he makes suggestions about what might be done.
Yes.
If we go to poll 308 9394, and if we go down, please, to the 3rd of December, reply from Mr Bolsh. The only clarification I think I need at the moment relates to the timeline, 2005 removal of cash. Could you clarify what this means and discount it as a possible explanation for the losses being to occur, beginning to occur at that time in the Sefton and Neil case? Audit reports will simply show the money missing, so will not take things further. Again, does that contain the loaded language about which you were critical before?
Yes.
Because it's an instruction as to what to do. Discount something as a possible explanation.
Yes.
Would you say that Mr Bolsh's rejection of obtaining the ARQ records in these cases was consistent or inconsistent with the approach of an open-minded prosecutor?
Inconsistent. It was a reasonable line of inquiry. It was allied almost inevitably to duties of disclosure.
Mr Jenkins signed a witness statement in this case on the 5th of December 2012. That's poll 305 9424. So again, so I think this is the 5th of December, maybe the 6th of December 2012, identical to the generic statement that had been signed back in October 2012, except for an additional paragraph addressing an aspect of Miss Sefton and Miss Neil's case. If we scroll down, we can see that. Scroll down, and again. And again. It begins, in substance, I've been asked to provide a statement in the case of Angela Sefton I understand the integrity of the system has been questioned. And this report provides some general information regarding the integrity of Horizon. And then if we go over the page, please. Generic statement that we're all familiar with. If we carry on, please. And again. If we scroll through just to see, this is the generic statement that we're familiar with.
Yes.
And keep going. And stop. And then just at the foot of, or just over the page, please. And we can see the line at the conclusion where Mr Jenkins says, I would conclude by saying I fully believe the Horizon system will accurately record all data that is submitted to it and correctly account for it. It cannot compensate for any data that is incorrectly input into it as a result of human error, lack of training or fraud, nor can any other system. I think I skipped over, I think it was page 2. If we can just go back to page 2.
Yes, there's a reference to the defence statements on page 2.
Yes. If we scroll down, please. Yeah, there. That losses started in 2005 and that Horizon was installed at that time. Horizon was rolled out in 1999 and 2002. So I'm surprised at the reference to 2005. There was a change implemented in late 2005, the removal of the weekly cash report. They were thoroughly tested at the time. There's been no indication of there being any issues regarding this change. And the change has no impact on the overall integrity of the system, as outlined in the statement. You've seen now how the generic statement came about and the emails involving Miss Panter and Mr Bolsh on the one hand and Mr Jenkins on the other in November 2012, insofar as that statement was adapted to deal with the Sefton and Neil case.
Yes.
Would you agree that those underlying communications demonstrate that it was the Post Office's idea and intention that the statement should be a generic one?
Yes.
That it was represented to Mr Jenkins, secondly, that the cases in which his generic statement was being provided were not cases which raised specific Horizon issues?
Specific issues, no.
That when he sought clarity on what that meant and what could be done, the Post Office, through its lawyers, declined suggestions that further investigations be carried out.
Yes.
He wasn't, in any case, fourthly, provided any instructions, proper instructions as an expert in these cases.
No.
Less still instructions that were specific to the issues that arose in any of these cases.
Quite.
In paragraph 566 of your report, which is on page 199, you say that Mr Jenkins' statement in the Sefton and Neil case is generic in its content. It mirrors that served in the case of Allen, in which Mr Jenkins' statement reviewed data specific to that defendant and said he had also run through hypothetical issues with integrity and concluded there were no there was no evidence of any issues.
Yes, in fact, it's clearer to me now from the material I've further seen that he hadn't reviewed data specific to that defendant in the way that I thought he had.
Thank you very much. You tell us in paragraph 565, which is on page 198, that there's no reference by Mr Jenkins in his statement to his own 2010 report addressing a fix for an identified bug.
Yes, the same point I made in relation to Mr Allen and that case.
We should read that across.
Yes.
Thank you very much. So it's 5 to 3 now. I wonder whether we could take the afternoon break now and return at 5 to 4. At 10 past 4. 10 past 3, sorry. So that's my alter ego speaking.
Yeah. Can you just give me a clue about how much longer you'll be and whether or not there are likely to be questions from co-participants' representatives?
So yes, I'm intending to pick up at 10 past 3 and finish by 4 o'clock. I think there will be some questions from 2 or 3 CP representatives, each of which is 5 minutes or so.
Right, fine, thank you.
So good afternoon. Can you see and hear us?
Yes, thank you.
Thank you very much. So can we turn to the case study, Mr Atkinson, lastly, of Kayam Ishak. Can we dive straight in with the material, please? By looking at poll 305 9481. Again, this is about the genesis of Mr Gareth Jenkins' statements. Poll 305, thank you, 9481. And if we scroll down, please, email from Mr Jenkins to Miss Panther of the 8th of January. Thank you there. Copied to Penny Thomas. Rachel, I've taken my previous statement and amended it to refer to the Ishak case. That's the generic statement that he's saying he's taken. Reading through the prosecution and defence summaries, I don't think there is anything for me to comment on specifically. Please, can you confirm this is all you need in this case? If so, I'll get a signed copy together with the related exhibits to you. And then if we scroll up, please. Morning, Gareth. Thank you for your statement, which I've had the opportunity for you to read. There's nothing that you need to add. It covers everything. And then forwarded by Miss Panther to Martin Smith, if we scroll up. Please see below, I've read the expert's report and it is perfect. In your report, it's paragraph 611. On page 215, no need to display it at the moment. You characterise generally Mr Jenkins' statement of the 15th of January 2013, which is the one being referred to in these emails, as a generic one.
Yes.
In the light of the emails that we've just looked at, would you agree that this was a case in which the Post Office sought a generic statement from Mr Jenkins?
In the main, yes, although the email chain that we're looking at here, the email that we started at was a response from Mr Jenkins to an email from Miss Panther.
Yes, if we scroll down in this chain. Sorry to speak over you, Mr Atkinson.
No, not at all. The email header's at the bottom of page 3, but the content is on page 4. So I think bottom of that page.
Yeah, keep going.
And so Ms Panter is sending Mr Jenkins and copying a cast of thousands into a list of cases and indicating what, in some instances, she is sending him. And
If we scroll down a little further,
point number 5 in relation to the case of Mr Ishak, she provided him with a number of documents for his consideration, having asked him to prepare a report in that case and essentially setting out what Mr Ishak was saying. And so it is not absolutely clear what it is she was asking him to do other than to prepare a report, but she was not, on the face of that paragraph, telling him not to properly examine the issues in relation to Mr Ishak. I can understand, given the context and the history that we have gone through, why he may have considered she was just asking him to sign a copy of his generic statement for Mr Ishak's use, but equally it was open to him to have, as he did in other cases that we've looked at earlier, flag up things that had occurred to him having looked at those materials.
and indeed when he did provide a generic statement, a strictly generic statement, she, Ms Panter, regarded it as perfect.
Yes.
Here,
I don't share her view as to its perfection.
no. Here, she's providing him with a copy of the indictment, the summary of facts, and the defence case statement,
Yes.
and identifying a claim by Mr Ishak that he was not dishonest. He had to make reversals in order to balance, and that there had been a malfunction with the Horizon system.
Yes.
Can we go forwards then a couple of weeks until after this statement had been signed off to the 31st of January 2013, poll 308 9427. And if we scroll down, please, and again to the 31st of January. There we are, thank you. Rachel Panter to Gareth Jenkins and lots of other people. Week of 11th will be fine. Sorry, if we can scroll down a little further. And again. If we scroll up a little further. Yeah. Ishak, having served your report, the defence have queried it and are claiming that Ishak had to make false entries in order for the figures to reconcile as the Horizon system kept malfunctioning. That was something that he'd originally said.
Yes.
Please, could you make a note in your diary, as you'll be needed to clarify our position with Horizon. And then, can I just check there's nothing underneath this email? Yes, it's that. If we just scroll up, please. Our barrister has asked if you could read the defence case statement attached and make a list of your initial thoughts on the assertions he is making. We may need you to add a few of these comments into your report so that each issue is addressed. Do you consider it an appropriate or an inappropriate approach to send a defence statement to a prosecution witness, whether an expert or not, for generalised thoughts or comments?
It's unusual, certainly, in relation to an expert, and I couldn't imagine it happening in relation to a non-expert witness.
In particular, was it appropriate, given the context, that the Post Office had not given Mr Jenkins the kind of instructions which ought to have been provided to an expert, nor provided him with all of the material relevant to the issues in the case, nor giving him instructions as to what material himself to obtain.
No, right.
Looking at what should have been done, would this be right? The lawyers and the investigator should have looked at the defence statement and seen what disclosure obligations it gave rise to.
Yes.
Looked for what issues that it raised and which questions therefore required to be answered, and whether they were to be answered by expert or lay evidence.
Yes.
If expert evidence, properly to have instructed an expert with written instructions complying with the obligations I mentioned earlier.
Yes.
Do you agree that in addition to being provided with relatively scant information, an indictment, a case summary and a defence statement, asking Mr Jenkins to comment on the defence case or provide comments on a defence case was risky?
I suppose it would depend on what they planned to do with what he came back with, but certainly if they were then going to comply with their obligations properly, yes, it was.
I mean, previously the instructions had been don't look at the specifics of any case. Your generalised generic statement will do. They were now saying, we've got a defence statement here, can you provide comments on it? And you're saying that the risk or the caution that needed to be applied, the risk that arose or the caution that needed to be applied was dependent on what was intended to be done with the reply.
Yes, and I suppose that the issues might arise if Mr Jenkins identified something in an aspect of the defence statement that was nothing actually to do with him and expressed his view, for example, on the honesty or dishonesty of someone, that would give rise to issues in and of itself. But assuming that he focused on those aspects that had a technical element to them, then clearly his answers to them were potentially at least disclosable, and given the lack of focus as to what they were asking of him, it could give rise to all kinds of disclosure issues because his answers were rather unprepared by anything they'd given him.
This shift in approach,
Yes.
from the generic will do,
Yes.
to now we're delving into the specifics of a case,
Yes.
was that a moment for the lawyers to grasp the instruction of an expert with both hands and to do it properly?
Yes.
Can we look, please, at Mr Jenkins' comments on the defence case statement? Poll 305-9602. Comments on Ishak defence case statement, DCS, authored by Mr Jenkins on the 1st of February. He says he's been asked to comment on the defence case statement. I've copied the statement below in blue font and added my comments in black font. I'm not sure if the responses are of much use, or that the responses are of much use. And I don't think there is anything that can really be added to my statement as a result. However, if you feel any of this could usefully be added, I'm happy to be convinced. Much of it relates to requiring further data for analysis, and past experience indicates that help may be required in understanding it. I think you've seen this document.
Yes.
Mr. Jenkins, in addition to suggesting that further data may be required for analysis and that help may be needed in order to understand it, indicates in relation to horizon malfunctions that if the defence can specify some examples of this, I'm happy to investigate. However, I would contend that the system doesn't malfunction with leaving some trail to indicate what has happened. Without examining the logs, it's difficult to be more specific. in the light of that, do you agree that at the very least there ought to have been a discussion or a formal follow-up to the comments made about the need for further data analysis
Yes.
in order for Mr Jenkins to be able to look at the system malfunctions that Mr Ishak had complained about?
Yes, well, it's again a two-stage matter. So far as the prosecution's obligations are concerned, Mr Ishak had raised concerns from experience with the operation of Horizon. They were being told by their experts that an analysis of the data would assist in relation to that, and that they didn't need to wait for Mr Ishak to give them further and better particulars for them to know that that's what clearly needed to happen next. If there were further and better particulars from Mr Ishak, clearly that would further aid the process, but they weren't an essential prerequisite to anything being done at all.
In paragraph 611 of your report, that's page 215,
Yes.
you say the default statement and exhibits of Gareth Jenkins were served in this case. As has been discussed before, its service, the statement is a generic one. Do you agree that the provision and then service of a generic statement reflected the Post Office's intention that the statement be a generic one?
Yes.
And although Mr Jenkins explained his ability further to investigate the specific malfunctions of which Mr Ishak had raised, the Post Office did not in fact ask Mr Jenkins to do so.
No, that's right.
Yes, that can come down, thank you.
The further observation I'd make about that, though, is that Mr Jenkins was being told that he was, in the earlier emails we'd looked at from Miss Panther, that was being told he was going to be called at trial to give evidence as to the integrity of the Horizon system. In his mind, to do so needed, in that case, and given what was being said by the defendant in that case, he needed to look at the underlying data. So it wasn't just a matter for the Post Office, it was a matter for the expert exercising independent judgment to make clear to them that to do that, he would need to look at the data rather than it was just an option.
Are you saying that that should have been done by him because he knew that he was going to be called, and there would therefore come a moment at which it would be crunch time? He would be asked, or he might be asked, about specifics.
And so, at the least, he could have said in the course of these exchanges in clearer or more emphatic terms than he did here, if I'm asked questions about the operation of the Horizon system in relation to this particular post office, I need to look at the data to do that.
What about the suggestion that that was a function of the instruction of him being rather muddled, that he was told initially that the case raised no specific Horizon issues, then he was provided with some information about it. He wasn't asked to analyse underlying data. What was he to do?
That the instructions were muddled is clear, that they were inadequate is clear, that he could have gone back to them and said more. I consider also to be clear. I can understand how it came about, but that doesn't mean that it was not, in my view, clearly incumbent upon him to at least continue that discussion before he found himself in the uncomfortable position of a witness box, dealing with these matters, having identified that there's work that he could do better to prepare himself for it, and not being asked to do it.
By September 2012, at least Cartwright King was aware that the defence had intended to instruct forensic accountant, the cross-reference that we needn't look at it is Poll 00119433. And then 4 or 5 months later, Mr Jenkins was told about that. If we look, please, at Poll 00059808. If we scroll down to the 14th of February, please. Thank you. An update for you, Gareth, from Miss Panther. Our counsel, Mark Ford, would like you to attend court on the Monday before the start of the trial to allow you to discuss the case with the defence expert. This seems to be the first that, I should say, that Mr Jenkins knows that there is an expert.
Yes.
I think the rationale behind this is to narrow any issues that we may have with the defence from the outset, so as to try and reduce the amount of time you're required to attend. Our counsel is still waiting to hear from Defence Counsel and will update us if any issues arise. Your presence on the first day will still be required, so you can make your travel arrangements. Would you agree that suggesting to Mr Jenkins that he should attend on the first day of trial to respond to or discuss matters with a defence expert was alarming, given that Mr Jenkins had not been told about any expert before then?
That counsel had asked that there be a meeting between the experts to narrow the issues. In and of itself was a reasonable thing for them to have done. The rules now very much envisage that there will be a meeting between experts in advance of the trial in order to narrow the issues, but that is in advance of the trial rather than on the day it starts in the normal course of events. The experts would not come upon each other by chance at that meeting. They would know in advance what the other one was saying so that they could have assessed the content of those reports. So it isn't a matter just of Mr Jenkins' travel arrangements that needed to be planned in advance. He also needed to see the material in advance, and arrangements need to be put in place for how the experts were to meet, what they were going to address, and how what they discussed was going to be recorded so that others outside that meeting thereafter knew the outcome.
And so before this time, Mr Jenkins ought to have been told at least that there existed a defence expert.
Yes, and if it was contemplated that he would need at any point to respond to anything in that report, which was perhaps inevitable, then he needed to see the document from the expert as well.
Yes, i.e. the defence expert report.
Yes.
You just don't walk into the room with your hands in your pockets and say, what have you got to say?
No, quite. Who are you and what are you doing here?
Yes.
Yes.
And moreover, Mr Jenkins would not have known what material the defence expert had himself or herself examined.
Quite.
It would also, would this be right, mean that it would be difficult for Mr Jenkins himself to revert to any underlying data in advance of such a meeting to either decide whether to agree or to disagree with suggestions made in the defence expert report?
Yes, clearly that would be a more realistic possibility if he had reviewed the underlying data himself before producing his original reports that Miss Ibbetson's report was a response to. But yes, one of the reasons why an expert should see any other expert's report in advance is so that they can check it.
Can we look, please, at FUJ 00153977? we're now on the Monday, Monday the 18th. And we can see that Mr Jenkins has a conversation with Penny Thomas. Can you make out the conversation?
Yes.
Next week I'm going to Bradford for the Ishak case. I see you had some ARQs on this, and he gives the string of them. Do you still have the info you can pass to me easily? Then he gives the branch code. I can copy all you quote above out for you. That would be good. So at least I have the info, even if I don't have time to analyse it. And so it's apparent that Mr Jenkins was seeking to obtain material that might help him to answer questions and liaise with the defence expert, even though he had not at that stage been provided with a copy of the report or known which issues to address.
Yes, it's not clear to me where he had seen that they had some ARQs, whether that was because they were referred to in Miss Ibbotson's report or they were referred to in something else. But clearly something had told him that there was ARQ material available, and he had rightly recognised that he ought to see it.
How concerning was it that the Post Office, as prosecutor, was asking Mr Jenkins to go to court to respond to expert evidence without him having seen it?
Well, it's moderately remarkable to expect any witness, but certainly an expert witness, to deal with complex issues and to try and narrow those complex issues with another expert, not knowing what that expert said, not knowing what material they had seen, not being able to check either anything that they had said or that they had seen. I can't quite think how anyone thought that was a good idea.
Moving on closer to the trial then, to the 22nd of February 2013, which I think is the Friday before the Monday. Can we look please at FUJ 0015 3990? If we scroll down, please. Yes, that's right. We can see some travel arrangements being referred to on the 18th. And then if we go up, please. We can see Ms Panter's reply if we keep going. On the 22nd, at 11:15 in the morning, there's some material about the Wiley case, and then urgent. We can see there's an attachment, addendum defence case statement. Please see attached. The defence solicitors in the case of Ishak have served an addendum defence case statement on us this morning, which attempts to particularise the problems with the Horizon system. Please could you have a look at the comments they've made and try to address as many of the points as you can in order that we can email that to our counsel, Mark Ford, ahead of Monday's trial. Apologies for such a last-minute request. I think there's no coincidence the service of the addendum defence case statement is last minute. And so at this point there hasn't been, it seems, an attempt on the lawyer's part, Ms Panter's part, to analyse the defence statement herself and isolate from it issues that Mr Jenkins would in writing be asked to deal with.
No.
It's just a forwarding and saying please deal with this, essentially.
Yes.
Mr Jenkins' response to that, please. FUJ 0015 3997. If we see his reply at 1:10, same day, the Friday, I've added my comments to the amended defence case statement. I've now had confirmation that Fujitsu have not supplied any details of any help desk calls to Post Office Limited regarding this branch. There's nothing I can easily do to address any specifics. And if we scroll down, please. Yeah, that was the response to the last minute request. Again, Mr Jenkins was pointing out to the Post Office's lawyers that he hadn't been provided with information that could be obtained by the Post Office in order to consider the very points raised by Mr Ishak.
Yes.
Can we go forward to FUJ 0015 6747? If we see, we're on the 25th now, the first day of trial, at 9:37 in the morning. Martin Smith sending to Mr Jenkins the expert report.
Yes.
With a blank email.
Yes.
So just an attachment.
Yes.
This is Beverly Ibbetson's report. And later that day, if we look, please, at FUJ 0015 4006. Miss Ibbetson herself sent Mr Jenkins at just after 2 o'clock the appendices, and there are lots of them, to her report, which Martin Smith, the solicitor, had not done. I think we can follow that up by looking at the attachment to Martin Smith's email earlier in the day.
Yes.
See, it was just a bald report rather
Yes.
than the attachments. And so was the result of that, to your understanding, that Mr Jenkins had to deal overnight with this rather detailed forensic accountancy report, which he had seen for the first time on the first day of trial?
Yes, that would appear to be the position.
He wasn't, unlike Miss Ibbetson, a forensic accountant.
No.
He hadn't been provided with any formal written instructions to be an expert in the case, nor had he been provided with any broader background to the case.
Beyond, as we've seen...
Indictment, case summary, defence case
Exactly.
statement.
Yes.
He had not been asked to obtain the data, albeit off his own bat had obtained some ARQ data
Yes.
from Penny Thomas. Would you agree with my characterisation of this episode, of this part of the prosecution being run chaotically and with little or no grasp as to the significance of the need properly to instruct an expert?
Yes. The focus in this case appeared from the investigative and prosecutorial point of view to be that Mr Ishak had made allegations against an employee or a colleague. There was a lot of focus on him and not a lot of focus on anything else.
If we turn up paragraph 619 of your report, which is on page 218, you say 218 page, and then paragraph 619. although Mr Jenkins was engaged, he was not asked to analyse the underlying data, and there were serious shortcomings to the disclosure of material within his knowledge relevant to the operation and reliability of the system, and as to cross-disclosure from other cases. This continued to be the position even after focused defence requests and the instruction of a defence expert who, like other experts before her, relied on the material and information provided by Mr Jenkins to reach her conclusions. That last part, is that in fact in error, that she wasn't reliant on what Mr Jenkins provided her?
Yes, I think that must be right.
In this case, as in others, is it right that disclosure was not made in relation to the earlier bugs, errors and defects in particular, which had emerged in the Seema Misra case?
That's right.
Thank you very much. Those are the questions that I ask you. There may be some additional questions from other core participants. I think starting with Mr. Steen. Thank you.
Mr Atkinson, you're aware that I represent a large number of sub-postmasters and mistresses.
Yes, thank you.
You answered questions from Mr Beer earlier on as to whether there was a system in place that allowed those investigating or lawyers dealing with the prosecution of sub-postmasters the ability to access material down the corridor.
Yes.
Can we just take that one stage further? You're aware, I believe, that there were two helplines set up for sub-postmasters and mistresses. One set up by the Post Office itself, and the other, if I can call it loosely, a Fujitsu helpline.
Yes.
Regarding the Fujitsu helpline, you're further aware that that had 4 layers to it. A simple, if you like, answer the telephone, and we believe driven by scripts. Those answering the telephone, our clients say, would basically tell our clients to pay up if there was a shortfall. But there were also other layers to the helpline run by Fujitsu, which were resolving issues if there were issues concerned with the Fujitsu Horizon system. Is that correct? You're aware of that?
Not to any great extent, not least because there wasn't very much discussion of the different layers of the Fujitsu helpline in any of the material that I saw.
But outline, you're aware that there was such a helpline?
Yes.
And you're aware that there were individuals involved in the process of and fixing issues, bugs, errors, defects within the Horizon system insofar as they could?
Certainly I was aware that there were people who could be called at Fujitsu when there was a problem. Whether it was identifying bugs or not is a separate question.
All right. So not only would you have, if you're investigating a particular branch, an inability to access a library of faults and problems with the system, but also have you seen any way that investigators and lawyers would have access to the results of the telephone line complaint system?
Well, they were clearly able to obtain records and the content of contact with the Post Office's own helpline, because there are references to that. They were clearly able to obtain records of and the content of contacts with the Fujitsu line, because there were occasions when I think it was a gentleman called Mr Duncan made statements in particular cases about selections from that.
Did you see anything to suggest that there was a joined up type of thinking, that when one sub-postmaster was saying that the system won't work, can't find out what it is, there are these problems and trying to explain it, that was then linked to other individuals that were making similar complaints?
No, on the contrary, they would, when they did it at all, would look just at calls from the person they were investigating to the helpline, rather than, on some occasions, even other people at the same branch.
So we've got a lack of access to overall the picture of what's going on and the faults within the system. We've got a lack of overall access to the complaints and the difficulties that have been encountered by sub-postmasters and mistresses. Do you agree?
Do you mean access by a defendant?
Access, first of all, by investigators and the lawyers.
In the sense that they didn't access
Yes.
it rather than they couldn't access it?
Yes.
I agree.
Let's move on to the other way round. Now, you've been giving evidence in relation to the system of disclosure that is operated through the criminal justice system in the criminal courts.
Yes.
That's a system that operates in both the Magistrates' Court and the Crown Court, yes? And you've been giving evidence about the disclosure system that is used by prosecutors. Can we reverse the coin? So, where an individual defendant is seeking to make further applications for disclosure, there's a system for that as well, isn't there?
Yes.
Right. So what we have, in fact, as a picture that relates to disclosure is, in theory, how it should operate is that the prosecution should identify relevant material that might or may assist the defence case.
Yes.
Okay. Now, there then is a system that relates to the provision of a defence statement by an individual, where the defence statement is not mandatory, but essentially it is what happens in the courts. The individual will then set out what their case is.
Yes.
Okay. Now, that system has been in operation now for some time.
Yes.
Okay. Clearly, until there is disclosure by the Post Office of the bugs, errors and defects within the system and the problems that the system can cause, in other words, create shortfalls, create hidden losses, it is very difficult for the defence to make applications based upon that material.
Yes.
The applications that can be made through the process, Section 8 applications, is that correct?
Yes.
And that would be essentially saying that we wish to have material that relates to a particular aspect of a defence case.
Well, it's certain we have reason to believe that you have material that will help us in relation to this.
Yeah. And the way that that can work, and you've been, you've prosecuted many cases and you well know that I've defended in many cases. The situation is that a defence, once on notice of such material, can then make an application for it. If you're prosecuting the case, you can respond with the release of material that you believe is relevant to that request. Is that correct?
Yes.
And that process can continue. In fact, it can be quite a continuation of a process as more and more material is targeted and found for disclosure purposes.
Yes.
Eventually, a judge is brought in to sometimes resolve any issues that lay between the parties.
Yes, and the stage that can intervene between those is particularly after the service of a defence statement, and as was the case in most of these cases, there are letters from defence solicitors asking for further disclosure without going to the extent of waiving Section 8 at the prosecution, because the prosecution have a continuing duty of disclosure, and so the defence ask, and it is often if the prosecution either responds saying no or don't respond, that a Section 8 application may follow.
Yes. So where we're talking about the starting point, the inability or the failure to look into the questions of errors and defects within the system that you've been discussing with Mr Beer, when we're looking at that as a starting point, we don't in fact find that there's much of an ability for the criminal justice system to bite on these disclosure processes as you go through, unless you get that starting point right.
All that can happen is that against a blanket of silence in relation to a particular topic is the defence can ask for disclosure of material that might touch on the reliability of the system, as in most of these cases they did. But there is a limit to how far that can go, certainly in terms of any particularity, without something to bite on, you're right.
Now, other aspects that you've been discussing with Mr Beer relate to individual sub-postmasters that have, Mr Holmes is an example of this, that complained about the system, said that this thing, the machine wouldn't work, essentially, he was saying, and that he rolled over, essentially didn't account for those losses in the way that arguably the post office required, because otherwise he couldn't keep the post office open. You're aware of that?
Yes.
So essentially people were placed in an invidious position. Do you agree that sometimes faced with what was an unaccountable loss, they would then have to try and account for it. And those sorts of cases were dealt with in the Criminal Court of Appeal in the combined case of Hamilton, so that individual pleas of guilty, even to false accounting, were overturned. Do you agree?
I'm not sure it's for me to express a view on the nature of their position. I can confirm that that is what was said in a lot of these cases that I considered, and what was said in a lot of other cases as well that were dealt with under the blanket of the Hamilton decision.
The burden on criminal solicitors and defending solicitors and defending counsel was therefore made rather, I'm about to say more difficult, but made very difficult indeed. Stymied in relation to disclosure processes and an entire system that seemed to thwart the ability for sub-postmasters to make good what was going on at the post office branch. Do you agree?
I think slightly disentangling that. I think from the position of those acting for a defendant, where their instructions were, if they were in accordance with the interview, I don't know why this happened, but it must be the system because I can't explain it otherwise. That they would be up against, particularly once generic statements started floating about, a positive assertion that there isn't something wrong with the system. And so you have on the one hand a defendant saying it must be the system, you have the prosecution's evidence saying it's not the system, and you then have to decide whether you allow your client to proceed to trial against that wall, or whether you discuss with your client the possibility that a plea to something less than theft will keep them out of prison. And that's a decision I wouldn't, or a conversation I wouldn't envy anybody.
You've been referred by Mr Beer to a document. I'll take you back to it, please. POL 000 59424. Statement of Mr Jenkins.
I've seen a few of those.
My screen's not working, so I'm just going to use Mr Jenkins. So I can see it from afar. It's that one, actually. Sorry. Now, you'll see there that in relation to Mr Jenkins' statement, that if you look at the first page, and if you take your eye down to the first part of the page, you'll see a sentence that says, however, I understand that my role is to assist the court rather than represent the views of my employers or Post Office Limited.
Yes.
Now, in your statement, as an example at page 241, paragraph 674.
Yes.
You discuss there your issues that have been brought to your attention regarding the instruction of Mr Jenkins.
Yes.
And have you found anything within the material that you've examined that explains why it is in Mr Jenkins's statement, he also refers to his own statement as a report within the body of that document, have you found anything that explains why it is Mr Jenkins's report stroke statement says, however, I understand that my role is to assist the court rather than represent the views of my employers or Paul?
No, I mean, it's not because they didn't discuss with Mr Jenkins or provide for Mr Jenkins instructions as to his role as an expert at all. There's nothing in the post office communications with him that told him that.
Is that a normal sentence or paragraph to find within a statement, an ordinary witness statement?
It's part of a normal sentence.
Normal for who? Normal for what type of witness?
Well, you would normally expect to see a much more detailed explanation of an expert's understanding as to what their role was and who they were there for. You might find a sentence rather more like that in the statement of a witness who is making clear that they're speaking for themselves rather than for their employer. For example, if they were giving not expert evidence but factual evidence about a situation that occurred at work, They might make clear they were speaking for themselves rather than for anybody else. But if this was seeking to be ticking the boxes of the criminal procedure rules in relation to what a statement from an expert should say about their role as an expert, then it doesn't do it.
But it's a curious sentence to have within such a statement, because what it appears to do, at least in part, is provide a direction of travel going towards an expert report. Do you agree?
It perhaps shows an awareness that he was providing evidence as an expert without really understanding what, or at least setting out what that meant.
Yeah. And obviously you're not privy to any discussions, oral discussions, between Mr Jenkins and solicitors or advisors on behalf of the Post Office?
No, or indeed of Fujitsu.
Thank you, Mr Atkinson.
I think Mr Maloney has some questions as well, sir.
Thank you, Mr Beer. And Mr Atkinson, I represent a large number of postmasters.
Yes.
All of whom are prosecuted and convicted.
Yes.
And all of whom have since had their convictions overturned.
Thank you.
And I wish to just ask you about the case of Kayam Ishak.
Yes.
And if at any time you can't hear me, please say so.
You're very kind.
I want to ask you about disclosure around what happened in Berkenshaw Post Office after Mr Ishak was suspended. Now, Mr Ishak was very clear from very early in the proceedings that the Horizon system was the cause of the apparent shortfalls he'd suffered.
Yes. I think he also made reference to someone else who worked there, but Horizon was part of his account from the outset.
Right, he was essentially saying that one of the people who worked there had also done the balancers.
Yes.
And so that needed to be looked at.
Yes.
And that, absolutely. And
Yes.
indeed, you referred to that gentleman, Mr Liaquat Ali, during your evidence when being asked questions by Mr Beer.
Yes.
Now, I just want to show you a few documents, if I may, around this issue I've raised about disclosure after Mr Ishak was suspended and get your views on the disclosure process around this issue. Yeah.
Okay.
So the first document I'd like you to look at, if you would, is POL 20119445. Here we are. And this is an email from Martin Smith on the 28th of January 2013. And it's to Steve Bradshaw, who was the investigator in this case,
Yes.
the lead investigator, copying in Mark Ford, now Mark Ford King's Counsel, who was prosecuting counsel in the case.
Yes.
Usual introductions, but the final paragraph I'd like to take you to, it's down towards the bottom of the page, and we probably read it without having to focus in on it, but it says, given the stance which the defendant is still taking with regard to the matters flowing of the Horizon system, or the malfunctioning rather of the
Yes.
Horizon system, is it possible to establish whether the subsequent sub-postmasters had any problems with the Horizon system? After all, the kit in the branch would presumably have remained the same. Many
Yes.
thanks, Martin. So what we see there is that by the 28th of January, Mr Smith thought it a good idea to prove that any discrepancies could not be due to the Horizon system or its associated kit by reference to what had happened to the sub-postmasters after Mr Ishak had been suspended.
Yes.
Yeah. By the 31st of January, that email being the 28th of January, so some 3 days later, Mr Bradshaw had completed and signed a statement which was served as part of a note of additional evidence. And that statement is POL 30-59592. So this is 3 days after that email, Mr Smith, the solicitor, the reviewing lawyer, suggesting that this issue be addressed. And it's over to the second page of this statement. You see that's dated the 31st of January 2013.
Yeah.
And we see that starting the next audit was in February 2011, when Mr Ishak was suspended and a discrepancy in the accounts was discovered. The cash and stock was then transferred to an interim sub-postmaster in February 2011 and accepted as being correct. The cash and stock was again transferred to a new interim sub-postmaster in September 2012. During the subsequent transfer of cash and stock after Mr Ishak's suspension in February 2011, no problems or discrepancies have been reported. We see there.
Yes.
Yeah. So that statement was, as we see, served in the prosecution case. It wasn't unused material, it was part of the prosecution case, designed to assist in demonstrating that there were no problems with the system.
Yes.
And that's pursuant to that suggested email, that suggestion in the email from Mr Smith to Mr Bradshaw on the 28th of January.
Yes, so it would appear.
Yeah. There was then a mention of the case of Ishak in early February of 2013. And if we could put up the document POL 59652, yeah. We see this again. It's an email from Martin Smith. It's dated the 6th of February, and it shows that Mr Smith had been to Bradford Crown Court on the morning of the 6th of February for the mention, and the defence were unable to persuade the judge to order any further disclosure. It's to Steve Bradshaw again, with Mark Ford copied in again. The important paragraph is the second one. The defendant's solicitor told me that the defendant still operated the store in which the post office is situated. The defendant had instructed them that both subsequent sub-postmasters had told him that they had experienced problems with the Horizon system. Although you've said in your final statement that, quote, during the subsequent transfer of cash and stock after Mr Ishak's suspension in February 2011, no problems or discrepancies have been reported, the defence may well suggest that this does not necessarily mean that no problems were encountered by the subsequent SPM. I think it would be sensible to obtain statements from both subsequent SPMs confirming that they experienced no problems with the Horizon system, etc. Yeah. So, first of all, Mr Smith has got the statement of the 31st of January. Now he's looking for essentially corroboration of what Mr Bradshaw says in that statement of the 31st of January by seeking statements from the subsequent sub-postmasters.
Yes.
Essentially saying, we better get some statements from those postmasters to support your assertion. There's then a letter dated the 8th of February 2013 from Mr Ishak's solicitors to the post office. And that is poll 59675, please. Thank you very much. And if we scroll down, please. So this is the 8th of February 2013. The mentions being on the 6th of February 2013, 2 days later. We see Musa Patel, that's down at the bottom, as the solicitors for Mr Ishak. And the second paragraph reads, further to the service of the additional evidence at page 43, Stephen Bradshaw's penultimate sentence states that no problems or discrepancies have been reported since the transfer to a new interim sub-postmaster since the suspension of Mr Ishak in February 2011. With regards to this, could you please clarify whether further inquiries were made, i.e. has a full audit been undertaken since February 2011, and if so, what was the outcome of that audit? If no discrepancy has been highlighted from a subsequent audit, then please be on notice that we will require that data to commission our own audit, and then they look forward to the response. So the defence is essentially saying, we know that you say, and this is on the basis of Mr Bradshaw's statement, that there's no reported discrepancy, but have you done an audit? And if there is no discrepancy. We want to carry out our own audit, and actually you know that we've got an expert in place to be looking at this in any event.
Yes.
Yeah. So putting them on notice, as they say, that they will carry out that audit, please. There's then another email from Mr Smith, this time to trial counsel Mark Ford, and this is POL 59675. Thank you. Is that right? I'm sorry, I've just given you the same reference to the letter from Musa Patel, and I'll just have to check the appropriate reference for the email. In fact, I can read the email rather than going back to that, but it's quite short. And it reads as follows. Hi, Mark. So it's to Mr Ford from Mr Smith, copying in Mr Bradshaw. Just to keep you in the loop, please find attached a copy of a letter which we've received from Musa Patel's today. So that shows that the email is the 8th of February or thereabouts, and it refers to the letter that you've seen from Musa Patel's.
Right.
Steve is in the process of taking statements from 2 subsequent sub-postmasters who have not experienced any problems with the Horizon system. They've not had any significant shortages. So essentially, following up on what he said to Mr Bradshaw about getting the statements.
Yes.
Then referring to the request from Musa Patel, he says, I do not propose to ask Steve to obtain the data for the period following Ishak's removal. Given that there were no problems with the system and no significant shortages, it would not assist the defence or undermine the Crown's case. So he's essentially saying to Mr Ford, they want the data, Mr Bradshaw's getting the statements I suggested, and he tells him he's made a decision that they're not going to get the data on what is essentially the disclosure test. It won't assist or undermine because we have the statement from Mr Patel saying there were no significant shortages. And he's notifying Mr Ford of the line he's going to take.
Yes.
Now, we don't have Mr Ford's reply to that, but we do have the letter that Mr Smith then sent to the defence. And that is POL 59729. And it's the first paragraph of that, and it's dated the 15th of February of 2013. And it reads, thank you for your letter of the 8th of February 2013. We enclose in duplicate copies of a notice of additional evidence, the statements of Stephen Bradshaw of the 11th of February 2013 and Abdullah Patel of the 13th of February 2013 and an up-to-date page count. There is no further disclosure to be made in this case. Now, that's one sub-postmaster, Mr Patel, and essentially that statement simply says, I've had no significant shortages and there's been no problems with the kit. And then simply says, and no further disclosure to be made. Now, the purpose of these statements was to make the point that because subsequent sub-postmasters had experienced no significant shortages, then there can have been no problems with Horizon in Mr Ishak's office at the time he was involved with it.
Yes.
It was thus a point that the prosecution relied on in respect of a material issue in the case. And it was therefore incumbent on the prosecution to prove the point. I couldn't hear you then, Mr. Atkinson.
I'm so sorry. Yes.
Thank you. And having commenced on that strategy for proving their case, it was an important part of proof of the integrity of Horizon.
Yes.
And the defence, in saying that they wished to audit the data for that period, was indicating that it wished to put the prosecution to proof on that point.
Yes.
Now, if the data for Berkenshaw Post Office after Mr Iqbal's suspension had shown that there had been shortages, that would obviously undermine the prosecution case.
Yes.
It would mean that the prosecution couldn't prove its point on that part of the case.
Yes, it would probably go beyond that in terms of calling the operation of the system into question, as well as proving that their specific point on it wasn't a valid one.
And as a natural corollary of that, it would assist the defence case.
Absolutely.
Yeah. Now, as the reviewing lawyer, could Mr Smith, forgive this, it may be a rhetorical question, could he know that the data would not undermine the prosecution case or assist the defence case without seeing the data or asking Mr Bradshaw even to get the data?
I suppose it's a two-stage thing. If he had, and it's not clear if he had from what you've shown me, if he had the results of audits that showed at points during that period that there was nothing untoward, that would allow him then to assess whether the underlying data took matters further. But on the face of this, they weren't even giving any results as to audits.
And wasn't he, in essence, refusing the defence the data to make its own checks on that point that the prosecution wished to prove?
Certainly on what you've taken me through, it appears that the defence was saying, in the first instance, have you looked to see whether there are any problems by looking for audits? That question, as far as I can see, was never actually answered, nor indeed asked by the reviewing lawyer of the investigator. And so the decisions that, on the face of it, were being made in the absence of knowledge, which is never the right position to be making disclosure decisions about.
And simply a bare assertion that there is no further disclosure to be made without any explanation of that.
Well, making the assertion there's no further disclosure to be made when, on the face of it, he didn't know whether there was any further disclosure to be made.
Thank you very much. That's all I asked, Mr Atkinson.
And I think lastly, Mr Henry, sir.
Mr Atkinson.
Henry, before you start, I unfortunately have to rise at 4:25 today. I've got no choice in the matter, so I'm sorry you're confined to 10 minutes, but you'll have to blame your colleagues who told me they'd be 5 minutes and took about half an hour between them.
Yes, thank you, sir. Mrs Adedeo's overturned conviction, you will agree, is a shortfall case.
Yes.
Because, of course, as an irreducible minimum, the calculations that gave rise to the shortfall are dependent upon data generated and provided for by Horizon.
Yes.
And I don't ask you, of course, to comment on the merits of this, but a shortfall which she had a stark choice whether to submit to them, the figures that is, sign off on the figures, or cease trading, while still remaining liable for the shortfall.
Yes, again, I'm not familiar with the details of the contract, but that is my understanding from what I've seen.
Yes. Now, you are also now aware that before Mrs. Bernard, the investigator, had arrived at the scene, there was the backdrop of an interview conducted by an auditor in breach of pace.
Well, I'm aware that there had been a conversation between Mrs. Adedeo and the auditor. The material, I have to say, that I'd seen, certainly before the end of last week, as to the nature of that and the extent of that conversation was very unclear. The investigation report, for example, didn't really fill in the gaps as to what had happened, and there, I think, was no statement from the auditor.
But it resulted, that's correct, but it resulted in what I'm going to describe in inverted commas as a confession, did it not? Although of an equivocal nature.
Certainly there was reference in the investigation report to admissions having been made, which were then addressed in the sense there were questions were asked about them in the interview. Mrs. Adedeo's answers about them rather less clear to
exactly.
To follow.
Now, that interview that was actually later conducted following that, what I'm going to describe as the equivocal confession to the auditor at the scene, but the formal interview conducted by Mrs. Bernard was, well, it elicited contradictory, confusing and internally inconsistent answers, as you have accepted.
Yes.
Described by counsel to the inquiry as baffling, and you don't disagree with that?
No, I don't.
No. Yet no attempt was made by Mrs. Bernard to investigate Mrs. Adedayo's bewildering account, to probe or question the overall effect. In other words, as to whether there was any truth in the mysterious payments to third parties to whom she claimed she owed and had paid money.
Certainly, I saw no evidence of such inquiries, no.
No. And so, therefore, Mrs. Bernard then approached, and I don't mean this pejoratively, an interrogatory approach. In other words, she elicited through close-ended questions or leading questions an account which she proffered to her superiors.
Yes.
Now, if there was a risk that Mrs. Adedayo's account was unreliable because of things said or done, notwithstanding the paucity of the information that exists now, but of course the circumstances were very different then. If there was a risk that Mrs. Adedayo's account was unreliable because of things said or done, it would have been all the more important, would it not, to have actually investigated independently of what she was telling Mrs. Bernard.
If the investigator had concerns that it might be unreliable, then they needed to investigate it to ascertain whether it was or not.
Yes. And we know from evidence given to the inquiry what Mrs. Bernard said was her state of mind at the time was that she did not believe the account she'd been given, but she made no attempt, as she admitted to the inquiry, no attempt to investigate whether it was true or not.
Yes, I haven't seen or heard Miss Bernard's evidence, but I understand that from what Mr. Beer said a little earlier.
Yes, but an examination of Mrs. Adedayo's bank accounts conducted by a competent investigator would have established that there were no unexplained transfers of money in or out, no evidence of misappropriation, nor any payments alleged to those mysterious third parties. So can I just, in conclusion, ask you if you agree with this? Are we not left with the impression that Mrs. Adedayo's case was not properly investigated?
I can't say what would have been found had Mrs. Adedayo's bank accounts been examined, but then equally neither could the investigator because they didn't look.
Yeah. So...
And so it seemed to me that that was a reasonable line of inquiry, both to pursue what had happened to the money, to assess whether there'd been dishonesty, and, as you rightly say, to assess whether the account Miss Adedayo had given was a reliable one or not.
So we're left with the impression that it was not properly investigated.
And so, therefore, in those respects, it was not properly investigated.
And, therefore, that it was questionable to even charge in such circumstances.
Well, it was a situation where, to an extent, I suppose it would depend on the extent to which the investigator flagged up to the lawyer that whether there were any concerns about the account. If it was clear from, and I just don't remember, I'm afraid, whether it was clear from the investigation report that Mrs. Bernard had those concerns about the reliability of the account. If it was communicated in that way to the lawyer, then the lawyer, in my view, ought to have been asking questions rather than making charging decisions.
Exactly. And to adopt the word you used with perhaps characteristic understatement earlier, questionable to proceed in such circumstances without further investigation.
Yes.
Because we're left, are we not, with the, and we've got 1 more minute left with the potential, are we not, that this was a false confession, a bewildering, baffling and internally inconsistent account, and that the underlying allegations could have been merely an artifact of system error.
Yes, I think that's right.
Thank you.
I congratulate you, Mr. Henry, on the conciseness of your question. And I thank you, Mr. Atkinson, very, very much for all the assistance you've given me over a number of days at this inquiry. I'm extremely grateful to you.
Thank you, sir.
Thank you very much, sir. Thank you, Mr Atkinson. Sir, we reconvene tomorrow with Lisa Allen at, I believe, 10 a.m.
Yeah.
Thank you, which is the last witness for this year.
Thank you for reminding me, Mr. Beer.
Sir.
See you tomorrow morning, everyone.